I want to discuss the liability of tort. Fire risk assessors have responsibilities under the law of tort, which is where a civil wrong is committed. The principle is that there is a duty of care which could not be just owed to any direct contracting party but also to third parties. If there is a breach of any duty of care owed, a claim for loss suffered as a result of this could be made. What happens if there's no payment though for carrying out the fire risk assessment? Well, there is no liability under contract law, but there is still a liability under the law of tort. What are the basic principles of the law of tort? Well, firstly, there must be the existence of a duty of care. Secondly, the duty is owed to the person making the claim. There must be an act or omission in respect of a duty of care that is owed. The act or omission must amount to a breach of the duty of care owed. The breach must cause damage that is not too remote to the person making a claim. They are the basic rules for tort. Now, just because there's a contract in place does not prevent a duty also being owed under the law of tort. The fire risk assessor will still owe a client a duty of care. So basically they have duties in tort and contract. Now, for liability to be established, it must be determined that the fire risk assessor has fallen below the standard of care. And this standard is one of reasonable care and skill. What you have to ask yourself is, what would a reasonably competent member of the same profession have done in the same circumstances? Inevitably, the standard is set by the evidence of independent experts. Don't forget, these are independent. So as you can appreciate, it will be an objective standard. Now, a breach of any duty of care could be relied upon by a party to a contract or any third party who suffers loss as a result of any breach of duty to claim damages. Now, for a claim in tort to succeed, causation must be established. In basic terms, what it means is the but-for test. The person making the claim must prove that but for the breach of duty, the loss would not have occurred. So what are the potential breaches that a fire risk assessor could be prosecuted for? Well, clearly the main one is the failure to provide a written risk assessment. They might say, well, I'm not doing a written risk assessment for you. If they ask for it in writing, you've got to give them it in writing. The next one is the failure to correctly identify premises or other essential details within an assessment. You've got the failure to make the risk assessment premises specific. Now, this is the one that I feel many fire risk assessors may fall short of. You can't just carry out a fire risk assessment generic in a hotel, for example, and treat them all the same. Some hotels are single story, some are multi-story. Some hotels are listed, for example, castles that are converted into hotels. It must be specific to those premises. The next failure is the failure to conduct any actual survey of the premises for which the risk assessment is provided. Now, a common breach of this one is what we call the drive-by fire risk assessment. I have heard of cases where the risk assessor Google mapped the premises and produced a standard template without even entering the premises. Now, clearly the fire risk assessor is in breach of the regulations and could potentially go to prison. You've also got the failure to take into account relevant information that was provided. You've got the failure to identify the required fire precautions the person responsible has to take to comply with the order. So you've got to make sure that you identify the required general fire precautions. And finally, the failure to identify any significant findings. In other words, if you fail to identify what should have been identified, you are liable. Now, this one's a bit open to opinion because what one fire risk assessor feels is significant, another may not. And the only way ultimately to prove it will be when it went to court. For example, a smoke seal missing from a fire door in a corridor with alternative escape routes in a low-risk office building. Now, some people might think this is significant because it is a fire door, and others might feel it isn't because there is an alternative escape route and it's a low-risk office and it might not have even need to be in a fire door. Do you understand? So it's a bit subjective, that one. What about the damages that can be awarded? Well, the basic principles of damages is to put the claimant as nearly as possible in the same position as they would have been if they had not sustained the wrong for which they are seeking compensation. Now, for breach of contract, the claimant is to be placed in the same situation they would have been if the contract would have been performed. Whereas for a breach of tort, it would be to compensate the claimant for the loss caused by that breach of duty. Now, for both contract and tort, the loss must have been foreseeable. That's the key. It's got to be foreseeable and not too remote. In other words, some unusual thing happened, which is unlikely. It's got to be foreseeable and not too remote. For example, if a client contracts for a fire risk assessment to be completed by a fire risk assessor by an agreed date, for example, if it's a new building and it's due to be open, and the contract states that they will not operate the premises until the risk assessment is completed and any significant findings actioned. Now, if the fire risk assessor cancels the contract without any lawful reason at the last minute, well, the client now may not be able to open the business. All losses which are not too remote from the breach could be recovered, provided that the client had acted reasonably to mitigate any loss. Now, there is also another way that a client can claim damages, and this is called restitution. And this is simply, if a fire risk assessor unreasonably cancels the contract, then the client appoints another one to carry it out, and they can charge them the difference in carrying that out. Another example, which is a warning to all fire risk assessors, is if a fire risk assessor carried out a fire risk assessment and recommended the installation, for example, of a specific fire detection and alarm system, for example, an L1 system, and it subsequently transpired that the detection and alarm recommended was a significantly higher specification than required for the type of premises. For example, so they said specifying an L1 alarm system, which is full coverage in an office when it only needs a manual system, the client could seek to claim the difference in cost between a suitable fire alarm and the higher one specified. Now, this could have serious implications, because I cannot tell you how many times I have seen a fire risk assessor clearly over-specify what is required. They've recommended full maintained emergency lighting in a building that did not require it. And guess what? Yeah, the fire risk assessor worked for an emergency lighting company. In Cambridge, a home which was converted for people with special needs had a recommendation for a 10-foot fence with CCTV footage and security lighting to reduce the risk of arson. Arson? It was a peaceful, tranquil village with no cases of arson. In other words, the risk assessor must have gone through the checklist, seen that and just added it in. There is no way that was reasonable. No way possible. That completes the module on the legal responsibilities of fire risk assessors. Now, just before we go on, I just want to tell you this true story. This is a true story in America. A lawyer purchased a box of very rare and expensive cigars, and then he insured them against, among other things, he insured them for fire. Within a month, having smoked all the cigars, the lawyer filed a claim against the insurance company. And in his claim, the lawyer stated the cigars were lost in a series of smaller fires. Now, the insurance company refused to pay, citing the obvious reason that the man had consumed the cigars in the normal fashion. The lawyer sued and he won the claim. Delivering the ruling, the judge agreed with the insurance company that the claim was frivolous, but he did state nevertheless that the lawyer held a policy from the company in which it had warranted that the cigars were insurable and also guaranteed that it would insure them against other things fire, without defining what is considered to be unacceptable fire, and therefore was obligated to pay the claim. Now, rather than endure lengthy and costly appeal processes, the insurance company accepted the ruling and paid $15,000 to the lawyer for the loss of the cigars which had perished in the fires. Now for the best part. After the lawyer cashed the cheque, the insurance company had him arrested on 24 counts of arson. With his own insurance claim and testimony from the previous case being used against him, the lawyer was convicted of intentionally burning his insured property and was sentenced to 24 months in jail and a $24,000 fine.